Hello, ACC Northeast Chapter members, colleagues, and friends. Welcome to Counsel Corner. I'm Danette Wineberg, Chair of the Northeast Chapter's Advocacy Committee, and today I'm joined by Tom Bean, a partner in the law firm of Verrill Dana in Boston. We are going to be discussing a critically important case for in-house counsel that is pending before the Massachusetts Supreme Judicial Court. Its focus is on the fate of attorney-client privilege and work product privilege in internal investigations. When our chapter first learned of this case, we asked ACC headquarters, staff, and its advocacy committee to consider filing an amicus brief. They agreed, and ACC retained Mr. Bean to prepare the amicus. The brief was written and filed, oral arguments have been held, and now we await the court's decision. Tom, what is this case about?
Well, thank you, Danette. As you suggested, this case concerns the scope of the applicability of the attorney-client and work product privileges to internal investigations that are overseen by in-house counsel and/or outside counsel.
So, why is this case important for in-house counsel?
Danette, this case started about 8 years ago. A professor in Cambridge, England, developed an app that Facebook users would then use, and it enabled the professor to secure personally identifying information about the user, about the user's friends, including birth dates, gender, marital status, political interests. It basically gave this person a lot of information about the user. This professor sold this information to Cambridge Analytica, which you may recall from the 2016 election. Cambridge Analytica used this information to direct political advertising to these users. And this is part of what was alleged to have interfered in the political campaign in 2016 and for president in the US. So ultimately, what Facebook did when it learned that this had happened, it said to its users, we're going to conduct an investigation because we don't want your personally identifying information to be out there, and we want you to be comfortable that it's not going to be used or misused. So Facebook began its own internal investigation. And ultimately, it hired, as I said, inside counsel was involved, outside counsel was involved. But then, and this investigation took multiple years into which apps might be misused to secure personally identifying information of Facebook users. Well, the Attorney General of Massachusetts was concerned that the use of consumers' personally identifying information might constitute an unfair and deceptive practice. And so the Attorney General's office in Massachusetts served civil investigative demands on Facebook. A civil investigative demand is essentially a document request that Facebook needed to respond to. And Facebook responded to the first two sets of requests. Those went without incident. However, the third request asked for a lot of information about how Facebook had decided which apps it was going to investigate and what the results of those investigations were. In other words, they were seeking what on its face looks like Facebook's attorney work product and/or attorney-client communications. And so Facebook objected. They refused to produce the documents responsive to the civil investigative demand, and the Attorney General sought to compel enforcement. The Superior Court granted the Attorney General's requests and moved and ordered to compel Facebook to produce documents responsive to most of the requests. Facebook appealed directly to the Supreme Judicial Court of Massachusetts, and that's the case we're handling. As I said, it's Attorney General versus Facebook. So that's what the case is about. Now, why is it important? As I suggested from the facts, it's important because the documents requested by the Attorney General seem to fall what is traditionally thought of within the scope of attorney-client privilege and/or work product privilege. And so what we're really dealing with here is to what extent are those privileges going to be upheld in internal investigations? That's why it's important.
Yes, very important for in-house counsel. So this amicus on behalf of the Association of Corporate Counsel, how did you think about that amicus, and what were you seeking to accomplish in it?
What we wanted to accomplish in this amicus brief is sort of broaden the scope of the information considered by the court. Facebook, at least in some circles, is not the most sympathetic party. And we wanted to show the Supreme Judicial Court that this decision was going to have an adverse impact and chill internal investigations that are an essential component of compliance programs. And that we wanted to argue in broad terms that the law ought to encourage effective compliance programs, and that if there were no attorney-client privilege, or if its scope were narrowed, or if the work product privilege was narrowed, in this case, it would discourage in-house counsel from conducting internal investigations, or for at least from putting things in writing or doing things fully thoroughly. So that's how we sort of started to think about it. And the way we applied it was, one of the leading industries in Massachusetts that is also heavily regulated is healthcare industry. Healthcare is one of the key economic drivers of the Commonwealth's economy. Massachusetts has world-renowned healthcare institutions. Healthcare institutions are, for obvious reasons, heavily regulated. Concerns about patient safety, and because we have the government paying for many services through Medicare, Medicaid, other programs, the healthcare industry is heavily regulated. And we wanted to make sure, and the healthcare industry, because of this, has extensive internal compliance programs. What's more, the Department of Justice manuals encourage prosecutors to consider the effectiveness of compliance programs in deciding whether to charge companies or negotiate settlements with companies, or in recommending sanctions for companies that violated the law. And so hospitals not only have their own internal incentive to do things right, namely have an effective compliance program, but the government has incentivized the hospitals to have effective compliance programs. And we were concerned, as I said, that if the attorney-client privilege or the work product privilege were narrowed in this case, it would inhibit or discourage internal investigations and thus effective compliance programs. So what we did in this brief was we used a couple of hypotheticals that could come up in the hospital setting. One involving a payment for healthcare services, a Medicare, Medicaid issue, a false claims issue, and the other, a patient safety issue, to show that hospitals want to encourage people to communicate when they have concerns. Most hospitals, as I'm told, because I interviewed several general counsel in preparing the brief, have hotlines where staff can call in and report something if they have concerns. And the hospital said that one of the reasons staff are willing to communicate information is because they understand that information is privileged. And when in-house counsel goes to interview, or someone is acting at the behest of in-house counsel to interview a staff person, the staff people are more comfortable communicating when they know that the communications are A, privileged, and B, that privilege is owned by the hospital. So that's what we sought to do. Give the court a sense of the potential breadth of impact of its decision in an environment that was important to Massachusetts and the Massachusetts economy.
So while we're waiting for a decision on this case, what advice do you have for in-house counsel?
Well, I think in-house counsel should do as it has done. Know the scope of the attorney-client privilege, or what the requirements are. There are 8 requirements. And one of the keys is that the information be communicated to a professional legal advisor, where that person is gathering information to advise management. Communications obviously must be made in confidence by the client, and are therefore protected from disclosure by the attorney unless the client waives the protection. And so I think that's one piece of advice. The other is just be thoughtful. think about the privileges, the work product privilege, the attorney-client privilege, as you decide, make choices on your investigations. I always, when I worked in the government many years ago, they said to us, they jokingly said, don't put it in writing unless you're comfortable reading about it on the front page of the Boston Globe. I think attorneys, when they prepare information in connection with investigations, should consider, am I comfortable with someone reading this if the government, issues a civil investigative demand and gets a hold of it? Am I comfortable with what's here? So I think in the meantime, while we're waiting this decision, in-house counsel should continue to operate effective compliance programs, keep safeguards in place to ensure that the privilege is maintained and is not waived, and basically go about, conducting your business, doing the right thing, doing your job so that your compliance program is effective.
Good, thoughtful advice. So when should we expect a decision?
Well, the case was argued on December 4th of 2020. The Supreme Judicial Court's internal guidelines say that decisions are to be issued within 130 days. That's 4 months and 10 days approximately. So we are now, December, January, February, we're about 65, 70 days into it, I think. And so I'd say the decision is going to come down, if internal rules are followed, within 60 days.
Now I want to back up a little bit and ask how you became interested in representing ACC and preparing and filing this amicus.
Well, it turns out a law school friend of mine is on the board of the ACC, and he knows that a significant portion of my practice is appellate litigation. And when he recommended to you, Danette, I believe, that you talk to me about the possibility of my representing ACC in this matter. And so when I read up on it and saw the importance of the issue, it was easy for me to say yes to the ACC, to support the organization and support preservation of the attorney-client and work product privileges.
As you mentioned, appellate work is a significant part of your practice. What do you most enjoy about it?
If you had said to me in law school years ago that what I would enjoy most is research, writing, and argument, I probably would have laughed. But what I really enjoy doing is making law. Our common law system, as you know, law is made through judicial decisions. And to the extent I can have an influence on those judicial decisions to help shape the law as an advocate, I really enjoy that. There's nothing better than sparring with a judge over the law, where typically, the Supreme Judicial Court judges will have 5 cases in front of them in a morning where they've read the briefs in preparation for argument. But, they've got 5 cases, and that's 5 cases that day, and usually 5 cases the day before, since the court sits 1 week a month. And I've got 1 case to think about. So because I've got only 1 case to think about, I typically know my case better than the court does, or at least I should. The other part that's really, I'm an educator by training. And I really think I see my job as an advocate is to educate the court, help the court, show the court where in the record are the key elements, and explain why the decision should go a certain way. As I said, part of the goal in the amicus brief was to help the court see that its decision was going to have, or could have, far-reaching consequences beyond Facebook to industries, whether it be, as I said, healthcare, heavily regulated, financial services in Massachusetts is heavily regulated. Less heavily regulated, but important to the Massachusetts economy, is higher education. And so we wanted the court to understand the context, with the larger context within which its decision was going to have an impact.
Now, one of the things I've learned about you in working on this case with you is that pro bono is an important part of your work. Why?
Well, it is. Look, I'm fortunate to have been able to become a lawyer. I as I said, I feel incredibly fortunate. And part of what we have as lawyers is we have knowledge and skills that others don't. And we need to, I think we have a responsibility as attorneys to provide pro bono services. Back, was it about 2011, I guess, a clerk magistrate had allegedly engaged in some misdeeds. And the Supreme Judicial Court asked me if I would serve as an independent investigator and potentially a prosecutor with respect to the alleged misdeeds. And I called up a friend of mine and said, well, what's involved? And my friend who had done one of these said, oh, Tom, it's no heavy lifting. You'll conduct an investigation and you'll negotiate a resolution, a sanction with the clerk, probably, depending on what you find, and that'll be that. Well, that was not my case. I spent 500 hours of my own time, 2,000 hours of my firm's time investigating this clerk magistrate. He would not agree to a settlement. His basic attitude was, I've been appointed by the governor and I'm going to serve until the governor tells me I shouldn't, or something to that effect. And so we ended up having to have a 6-day trial overseen by a former appeals court judge. The case was appealed to the clerk's committee and then ultimately to the Supreme Judicial Court. And this clerk magistrate was removed from office by the Supreme Judicial Court. First time in 13, 14 years that had happened. So pro bono is important. It's something I think we all have a responsibility to do. And one of the pieces of advice I got about pro bono early on from a partner at the firm I was working at, she said, do pro bono that interests you. Don't do pro bono just because it's there. Do the type of case that interests you. And because you'll do a much better job than if you're just doing it to do it. And I have taken that advice. I thought that was very sound advice. So I say to those of you watching, as you think about what pro bono activities you might engage in or what cases, choose something that interests you. It can be within your area of expertise or something you want to learn about, but make sure it interests you because you'll be more enthusiastic and do a better job.
Thank you for that, Tom. And thank you for your work for ACC, for our Northeast chapter, and for your participation today in Counsel Corner. We will be back to talk to you after the court issues its decision.
Thanks so much, Danette.